Welcome to Season 2 of Athena Rising. My name is Vanessa Singh Johannes, and along with my colleague, Marisol Descalzo, we founded and host the Athena Rising podcast, which is geared towards telling real, authentic stories of lawyers around the world, particularly those of dynamic powerhouse women. Season 1 of Athena Rising focused on such women's stories, but for Season 2, we're doing things a little bit different. We are focused on allies of Athena's, without whose assistance we are unable to collectively break glass ceilings. Our guest today is not only an ally, but a skilled trial attorney who's coming off of a phenomenal criminal defense trial victory. Brian Heberlig is a partner at Steptoe's Washington, D.C. office, where, for over 25 years, he has first chaired white-collar criminal defense matters. I should add, since this is an Athena Rising podcast, that Steptoe's partnership is 28% female. That's an 8% jump in 10 years from where it was before. This is well above the national average of 20% female equity partners at major law firms. And in 2020, women ranked Steptoe as one of the top law firms for working mothers. Just this year alone, they continue to elevate women into management. A powerhouse lawyer, Sandra Hanna, was tasked to lead the firm's SEC enforcement practice and expand its white-collar and investigations group. On this episode, Brian will discuss why diversity, inclusion, and women in the top ranks is vital to an ever-changing and growing legal market. Brian is a force to be reckoned with himself, as you'll learn today. He is a fellow of the American College of Trial Lawyers and a 3-time winner of the American Lawyer Litigator of the Week. He is the co-chair of Steptoe's Investigations and White-Collar Defense Group, well known for succeeding in the bet the company type of cases. Brian, thank you for being a guest, and welcome to Athena Rising.
Thank you, Vanessa, for that kind introduction. I'm delighted to be here.
Brian, I'd like to get right to it with what is top of mind for most of our listeners, your latest trial. I'll give a brief background for our listeners, many of whom may not know what the case was about. So Brian was part of a team that represented Michael Lynch. Michael Lynch is the former CEO of Autonomy Corporation. This was a complex 11-week criminal trial before Judge Breyer in San Francisco in the Northern District of California. It was a federal case. Brian, your client was charged with 17 counts in a superseding indictment brought in 2019. And the charges stem from Mr. Lynch's time as the CEO of Autonomy. For those listeners who don't know, Autonomy is a software company with dual San Francisco and UK headquarters, which becomes important for a reason. Autonomy was purchased by HP in 2011. The government alleged that prior to that sale, from the time period of 2009 to 2011, Mr. Lynch spearheaded the artificial inflation of the company's financial value, lied to auditors and market analysts, fired, intimidated witnesses who raised complaints about the financial practices and the performance of the company, and, really just engaged in an overall scheme and conspiracy to hide the true valuation of the company. And he did so with the end game of selling Autonomy for an artificially inflated and very high price. And indeed, the sale price was high. HP paid $11.7 billion for Autonomy, and Mr. Lynch, I believe, directly received about $700 million of that. He was, for a while, dubbed Britain's Bill Gates. Before we get into the trial, Brian, what I'd like to talk about is what led up to the DOJ investigation and criminal charges. I'd like to talk about the investigation because for a lot of us in the white-collar space, we know that the investigative time is one where defense lawyers work really hard so the charges aren't brought. And here I know that you guys were well aware that Mr. Lynch was being investigated. I understand that HP filed a civil suit in the UK alleging essentially a scheme to defraud and artificially inflate the value, everything that I just mentioned. But tell us a little bit about how that lawsuit in particular, what that meant to DOJ and whether or not you thought that was the precipice for the DOJ investigation itself.
Yeah, no, I'm happy to. And I'll step back even before that. So the very first, I'd say, legal event in this case was the investigation began probably early 2014. As you said, HP acquired Autonomy in the fall of 2011. And Mike Lynch actually went to work for HP for about the next 6 months. And things, went along okay. But HP as a business was suffering greatly. And, they had to take some serious steps to write down the value of the company. And our position was they decided to blame things on autonomy. So about a year after the acquisition, there was a very public announcement by HP that they were writing down the value of autonomy, which had, as you said, had been acquired for 11.7 billion. They were writing down something like 8.5 billion in value, 5 billion of which they attributed to a massive accounting fraud, which took Mike and his former colleagues by great surprise, and it set in motion a major investigation by DOJ. HP was, lawyered up with the firm of Morgan Lewis, and they were led by Leslie Caldwell. They did this massive internal investigation and cooperated with DOJ. And the end result of all of that were sort of two things. One, the CFO of Autonomy, the former CFO, Sushavan Hussain, was charged criminally in the Northern District of California in a case that mirrored very closely the ultimate case that we took to trial years later. And around the same time, Hewlett-Packard filed a civil lawsuit in London, and both proceeded before our criminal trial. Sushavan Hussain was ultimately convicted in the same courtroom we went to trial in some 4 or 5 years later. And Hewlett-Packard won, at least for liability purposes, a pretty massive judgment in what some have described as the largest civil case in UK history that produced a massive 1,700-page written judgment by the justice over there. And so we, needless to say, we had a lot of prior material to work with by the time we got to our trial.
Let me ask you, the internal investigation that was conducted on behalf of HP, were you ever privy to some of their findings, and was that part of the discovery, who they interviewed, and I suppose the witness statements would have been, right?
It was part of discovery. That was a fight that was largely fought in the first trial of the CFO. He was represented by John Kecker and his partners, Kecker and Van Nest, and they fought with the government and with Hewlett-Packard over whether the internal investigation work product was still privileged. And ultimately, I think they gained access to interview memos of witnesses who were testifying in that trial, and then some of the findings and PowerPoint presentations and the like that HP had made to DOJ were produced in discovery. So we got access to all of that material in discovery in our case.
Okay. When was Mr. Lynch made aware of the investigation internally? Was that while he was still there, or was that after HP had already conducted the investigation?
Yeah, he was fired by HP about 6 months after the acquisition, and that really was before the internal investigation kicked off. He sort of had an ambush interview by the general counsel of HP as part of sort of his exit from the company. And therefore, they launched into this massive investigation. And we knew pretty soon after the public announcement by HP that there would be a DOJ investigation. They told the market they were referring the matter to both the DOJ and to the UK Serious
Right.
Fraud Office. So it was sort of on at that point.
Yeah, you knew it was coming. I mean,
For
what else
sure.
is going to happen? Yeah. Um, so at that point, well, is that when you're brought in? Is that when Steptoe was brought on board?
Yeah, we were hired back in, I want to say, whenever that announcement was by Hewlett-Packard, the big splashy press conference, we were hired within 2 or 3 weeks of that. And uh, closely in time to when Clifford Chance was hired, because there was also an expectation there would be some significant legal issues in the UK. You mentioned in your introduction that we were co-counsel at trial with Clifford Chance, and they, originally were the London firm handling the UK side of things. We were the US firm handling the DOJ investigation. But Clifford Chance's white collar expert, Chris Morvillo, wound up sort of covering everything and working closely with us in the US on the DOJ matters. And then he and I were sort of the lead co-counsel at trial.
When you came on board, I could imagine that at that juncture, when the investigations are ongoing, there were some efforts or steps made in order to, have, this be a no prosecution. For our audience listening, that's, when you go before the DOJ and you say, there's nothing here, don't prosecute, don't indict. Were those steps taken?
Well, I mean, there was some limited engagement with DOJ. I mean, obviously, our client was at the very top of the pyramid. So it was not a situation where there was ever any thought, we could cooperate against someone else. But there were some steps taken to advocate on his behalf. You know, as it turned out, they indicted the CFO and did not indict our client. And so, we thought we had dodged the bullet and that he was not going to be charged and was just going to have to deal with the civil litigation in London. But after the CFO was convicted, DOJ turned around and indicted our client along with the former Vice President of Finance, Steve Chamberlain. And that set in motion a fairly lengthy process in which the U.S. extradited Mike Lynch to face the charges.
So I believe your client was charged in a superseding indictment in March 2019. Is that correct?
That's correct. And the CFO's conviction was in 2018.
Okay, so perhaps on the cusp of that, when they were emboldened to proceed onward, and they did. The arrest and extradition of your client didn't take place until last May. That's very lengthy process. Given the timing of all of that, I mean, by that point, your client knows that he's under some sort of investigation, either by HP or by DOJ for almost 10 years. I'm assuming this is, tiresome and, just exhausting for him. Why didn't Mr. Lynch just face the music and come to the United States willingly?
I mean, he firmly believed that this case didn't belong in the United States. There was a very tenuous jurisdictional hook. Most of the relevant events occurred in the UK. Even though HP was a US company, it had used a special purpose vehicle, this foreign company, to, facilitate the acquisition. So he exercised his rights to contest the extradition. He wasn't a fugitive by any means. He wasn't going anywhere. He was in the UK, and if it was ultimately determined he was to be extradited, he was prepared to accept that. But he didn't want to relinquish his rights. So he was, very ably represented in the UK, and I think it was a close call. At the end of the day, he lost and was extradited and was sort of a model defendant when he got here in the U.S., fully compliant with all conditions, and it was never about any risk of flight.
That's really important to note because, I did a lot of reading about this case and the background of it to prepare for our interview today. And, the media does spin things. And so when you hear that he's arrested and extradited, they leave out the process that took place and the timing that took place. And I thought that was important to highlight. And I'm glad you brought that up, that he just wanted to go through the process for the jurisdictional hook, if you will. And he did, in fact, get a bond when he was here and was in San Francisco in compliance. So Clifford Chance and Steptoe, two extremely large firms, are brought in to defend Mr. Lynch, and various offices worked on this case. Tell me, as you're thinking about trial strategy, once the indictment comes down, he's arrested, he's extradited, he's here, how do you organize that with firms? Because I think people fail to realize on the back end of what's happening before a trial. There's a lot of work, and that's a lot of work even for one firm to, have a lead in place and to have everybody organized and have a role. But how did you manage that with two big firms?
It worked smoothly as you could, way smoother than I could have possibly imagined. And part of it was our client, Mike Lynch, was, he sort of ran his legal defense like he ran Autonomy. He wanted to be in charge. He had assignments. He had us motivated within, I would say, a month or two of his arrival in the U.S. And obviously, there had been work done for years before that, largely in connection with the civil litigation that actually went to trial, and we could talk about. But when he got over here, we had teams of lawyers assigned. We started out by organizing our work around the issues in the case, and it sort of emerged that Steptoe would handle the accounting witnesses. So by that, I mean the outside auditors at Deloitte, who were an important part of the trial. We would also take on the expert witnesses, if any were called. And there was a restatement in the case. We were responsible for those witnesses, although in the end, that evidence was excluded, which was a pretty important ruling. And we were also going to be in charge of the HP witnesses and the due diligence phase of the acquisition. Clifford Chance was going to focus more on the nuts and bolts of the transactions that were at issue. So they took on like the reseller witnesses and some of the internal autonomy business execs who were involved in negotiating the deals. It actually broke down, along pretty clear lines. And after a, fairly lengthy period of focusing on the issues, then we transitioned to witnesses. And I've never been as prepared as far in advance of a trial as I was in this case. And it was largely due to Mike's efforts, which, at the time were a little bit annoying, I'll be honest with you. Preparing cross-examination outlines 6 months or more before trial. But there was never a minute when the trial actually got here that I felt unprepared. So it was a great luxury to be, working that far in advance with an enormous body of evidence. We had, trial testimony from a prior criminal trial, the prior civil trial in the UK, and also the multitude of FBI interviews and HP interviews. And in some respects, it was almost overwhelming. There was too much prior Jenks material that we had well in advance of the trial.
You mentioned Mike's efforts, Mr. Lynch's efforts, in helping to organize the teams, organizing it with his background as an executive. Is he a lawyer by any chance, by
He's not
trade?
a
Or
lawyer. No, no, he's not a lawyer. He's a PhD. He actually goes by Dr. Lynch, although at trial we tried to just call him Mike, to sort of remove that formality. But he got a PhD in mathematics from the University of Cambridge, and he was a technologist, basically. He was the person who invented the technology that was at the core of autonomy. And, outside of that technology background, he also was good at marketing. Those were sort of the main things he focused on at the company. Definitely not a lawyer and definitely not an accountant, which was, quite important since the case focused on accounting fraud issues.
you mentioned that you had to, get your cross-examination outlines ready, 6 months in advance. Was Dr. Lynch reading them and looking at them and assessing them?
He was. I mean, you
That's
know, he,
really interesting for a client to do, I have to say, who's not a lawyer by trade. So how did you take to that?
well, so it was fascinating. I mean, he is probably the smartest client I've ever represented, and he had been living with these legal issues for the better part of a decade and had gone to trial. So he knew more about the case than probably any one of the lawyers, and he had a phenomenal near photographic memory. So he would
Wow.
review these outlines and, remember, oh, this witness in that prior proceeding said, that fact, and you might want to plug it in. Now, he was not offering his opinions on strategy, of what
Right.
issues to address first or how to go about cross-examining someone. But on the substance, he often had really good ideas. And I welcomed his input and his methodology was to be incredibly direct and blunt. And sometimes when before you got to know Mike, it could be a little intimidating, like, oh my gosh, this is some tough criticism. But once you sort of figured out that was just, Mike's style, he was direct. He would give you some feedback and then move on. I valued it. I really, even right up to the beginning of the trial, and in some cases during the trial, I'd welcome him reading my outlines and giving feedback. And, he often had really brilliant ideas that I hadn't thought of and I incorporated.
Right. He was like part of the team, which I guess also enabled you to learn much more about him as a person and his leadership style and weave that into how you represented him and, really explained him to the jury.
Yeah, it's funny. I mean, part of the trial, there were many different phenomenons, but one of the odd things of the trial, there weren't that many witnesses called who actually knew Mike and worked closely with him. But the handful that did described him in ways that were eerily similar to what I experienced preparing for trial with him. And, an example, one of the witnesses said something like, Mike pushed us to achieve things that we never thought we were possible to achieve on our own. And, it paralleled what he was pushing his legal team to do. And, we worked extremely hard and obviously got a great result at the end of the day. But, a large part of it was due to Mike's efforts in really corralling the effort and motivating us to be well prepared far in advance of trial. It was remarkable.
That is extraordinary. Because sometimes a client could be a hindrance in that process, and sound that he sounds like he was the complete opposite, which is wonderful to hear.
Well, what he said at the end of the day was, look, indulge me, share your outlines with me. I'll give you my feedback. You take what's useful, leave aside what's not. And ultimately, I'm going to allow the brain surgeon to do the surgery. Okay. At the end, I'm not going to be looking over your shoulder and telling you how to do things, but I'd like to be heard and I have, relevant things to say. And I thought that that was a great attitude. And, I incorporated what was useful, which, most of his comments were, but sort of how to go about it, how to examine a witness, the style, the approach. He was hands off about that. And not never once second guessed anything that went on in court, which I also really valued. He knew when it got down to it. He hired us because we were the legal experts and he wasn't a lawyer.
Right.
So I thought it was the perfect balance.
That's great. You also mentioned that you had an enormous body of evidence going into the trial. Did you, looking at all of that, did you say, first of all, how did you wrap your hand or, heads around it? But did you also say, okay, this is going to be really damning? This is going to be, the thing that we're really going to have to deal with. And if so, what was it?
I will say the body of evidence that we had in this case was greater than any case I've ever been a part of, and I've had some pretty big cases, but this, there were something like 85 or 90 underlying transactions that were being challenged by the government. There had been this, as I said, prior UK civil trial that spanned 9 months and produced this 1,700-page opinion by the judge. I mean, it was virtually impossible to even read the opinion, let alone digest it. And most of the witnesses who testified, if they had been part of all of the legal proceedings, you'd have a couple of days trial testimony from the CFO's trial, a couple of days from the UK civil action, and then, upwards of 10 different interview memos. So you really had to get your arms around a lot of material, and that's before you even got to the exhibits. The government marked exhibits in advance of trial, and we did as well. And the exhibit list had over 20,000 exhibits on it.
Oh
It
my
was
God.
it was impossible to even, carefully review all of the marked exhibits, let aside, or let alone the 16 million documents that have been produced in discovery. So it was one of those cases where, I mean, and this is a little scary. You're seeing documents during trial that I hadn't seen before. And
Well, you just didn't have the time or the resource. I mean, it would take, I mean, you're reliving a company essentially, a company that was, functional for over a decade. Wow.
absolutely, absolutely true.
So, how could you then say, okay, these are the damning buckets of evidence, and this is how we're going to deal with it when you have such a vast pool of information?
Well, there, I think we were advantaged by the two prior trials. So, the CFO trial it obviously went the other way, and he was convicted. That was the first case that went to trial. There was this same mountain of evidence, but they got their Jenks material like you get in a normal criminal case. A few days before witnesses testified, maybe a few weeks. I can't remember exactly, but there was a lot more unknown information going into that trial. And we had the luxury, it was mostly a luxury, sometimes a bit of a curse, but we had seen two different trials before. So, the central issues definitely emerged from those two prior proceedings. The key witnesses were known. There was less surprise than I would say, I experience in most criminal cases. Now, that doesn't mean there wasn't a lot of variety, and our trial wound up being quite different than the CFOs at the end of the day, but we sort of had a pretty good idea of what we were dealing with going into it. And we were able, we had all of those witness statements from the time of almost from the time of indictment. I think, as a technical matter, it wasn't until he was extradited to the US that we were granted full access to discovery. But we had almost a full year with all of the transcripts and Jenks material to prepare for trial, which you don't often have.
No, not at all. So let's talk about the trial itself. Let's move from that from the prep phase to the trial phase if you will.
Yeah.
Odds going in are tough. Look, I mean, the reality is now looking back, you could say, wow, okay, the government really didn't have a case. Of course, we were going to win. But I know personally, and as well as you know, that the government wins a lot. And you've won in federal court several times. You've beaten the odds, but the odds are what they are. And the government really does, usually win because, it's not just the evidence, it's the perception out there. It's hard to win over jurors once people are charged. Plus here, there's a civil suit already. HP was successful and a CFO was convicted. The mentality going in, you guys knew that there was an uphill battle. How did you deal with your client and getting him mentally prepared for, we're going to fight the good fight. We're working really hard to win, but hey, Mike, you got to know what the odds are here.
I mean, that's a challenge in every case. Here it was a little different because, as I said, Mike was a mathematician. He wanted statistics. He wanted odds on likelihood of success. And as you know, that's an almost impossible ask of a criminal defense attorney. And I don't like giving odds to clients because you can't, reliably predict. But I will say, despite the scary, overall federal criminal defendant statistics, we thought we had a better chance than most going into this trial. Agree with everything you said that, the odds are often stacked against you, and the government goes into court despite the presumption of innocence, with many jurors giving them the benefit of the doubt and believing that there wouldn't be a case if there wasn't something to it. So, we faced all of those normal challenges, but there was a reason why Mike was not indicted in the first go round with the CFO. It was an accounting fraud case, and he was pretty far removed from the accounting. There were elements of the case that were focused on his disclosures to the market in earnings calls and in other places, but it was hard for the government to tie those disclosures to the underlying accounting decisions because Mike was fairly removed from it, and it was also a unique case. We knew going in there weren't true cooperators in the normal sense of the word. No one pled guilty here. The closest we had was one former Autonomy executive was forced to enter into a deferred prosecution agreement, but it was pretty weak, and he didn't admit to much. So we had some things going our way, but yet, it's still a very stressful thing to be a criminal defendant going into a trial like we were, going into. And we also knew that the CFO who had been convicted was sentenced to 5 years. So we assumed that that was the absolute floor, going in if it went the wrong way for us. And that's scary for anyone to face. And Mike was no different. It was tough.
Mike had a co-defendant, Stephen Chamberlain, I think you mentioned earlier, the former vice president of finance. Did you strategize with them as you proceeded into the trial? And if so, how did you work out what your theme would be? And because I'm listening to you, but I also read some of the transcripts and both sound consistent in the sense that the theme was he's a great leader, well respected, tough guy, intellectual, but obviously is not an accounting expert. And this is an accounting case. How did you work that theme in with Mr. Chamberlain, who was the former vice president of finance?
Yeah, well, so number one, we worked very well with his team. He was represented by Gary Linsenberg, a partner at a Los Angeles boutique firm, wonderful trial lawyer, and we had a close joint defense relationship. So we definitely worked through the issues in advance. Our clients were differently situated, obviously, but in the end, where we came together is we both pursued good faith defenses that were heavily reliant on the work of the outside auditors, just from a different perspective. So, from Mike's perspective as a non accountant, our defense was essentially all of the facts were known to Deloitte, the outside auditors. They made the decisions they made in real time, which were to approve Autonomy's accounting decisions. And who was Mike to second guess them? He acted in good faith in reliance on their decisions. That was, our defense. Steve Chamberlain's defense was a little different, but ultimately was also, based on good faith. His position was, yes, he was an accountant and he was a direct interface with Deloitte, but just like, Mike relied in good faith on Deloitte, Steve did as well, and he pursued a defense that he was essentially an honest broker of information. He gathered up, the underlying evidence and facts related to all these transactions, and he passed them to the outside auditors for their review. And that the ultimate decisions, to the extent there was accounting judgment required, were not made by him. They were made by the CFO in conjunction with Deloitte. So we were kind of sandwiched around the CFO, who, by the way, neither of us maintained that he committed any wrongdoing. We actually, believed that he was on the right side of the accounting issues too, but we didn't have to, fully rely on that position being correct because there was separation between us and him and between Steve and him. And ultimately, Deloitte's clean audit opinions were critical in the case, and the jury told us afterward that they found it to be quite relevant.
Yeah, I mean, it's one of the big four. So it's not like it was, Joe Blow, the accountant down the street. It was Deloitte. What during the trial, I'm curious, did any of the client relationship managers or the accounting managers for this for autonomy from Deloitte testify?
So there were two Deloitte outside auditors who testified. Um, they were not the relationship partners or I think they called them the audit partners. These were more of sort of the middle to junior staff members of the team, which I found interesting, frankly, that the government chose not to call the senior partners who were the decision makers. They called the
Right.
day-to-day, managers of the audits. But the government, they didn't challenge Deloitte's accounting on the merits, and they never sought to impeach either of those Deloitte auditors. Their position was that Autonomy misled Deloitte, that they gave them either incomplete or inaccurate information. But the problem for them was the evidence really didn't support that. And there might have been a few things around the edges where you could say that that was true. We maintain that they were largely immaterial. But on the key transactions, there were these hardware sales at Autonomy that were sort of the central issues in the case. Deloitte, I think almost objectively, had full information and agreed with Autonomy's accounting decisions. And that was very difficult for the government to overcome.
I'm curious if you all used a jury consultant in order to prep for trial. And if so, or even if you didn't, how were you able to make, your client, Dr. Lynch, Mike? And what I mean by that is, even I read some of the openings. The openings, you all referred to him as Mike and really humanized him as just Mike's, this relatable guy. It's hard to do when he is worth more than 99% of the public, when he lives a very different life, and he's the CEO of a company that was sold for, frankly, a lot of money. So I'm curious if you used a jury consultant in that process. If you did, or even if you didn't, how did that help in making him relatable?
Yeah, I'll unpack it a little. So we used a jury consultant, but not to prepare Mike for testimony or to develop trial themes. We used them in the more traditional sense to help us pick a jury, to do research on the pool, and they were very good at that, responsive, helped get us a lot of information. But since Mike had already testified and there had been a lot of prior legal proceedings, we didn't do like any kind of mock exercise before, or at least with the use of jury consultants. We did a little bit of internal mock examination of Mike. But yeah, we used the consultants for a different purpose, and they were good, but we didn't use them in the way that were suggesting or asking about. I will say, to get to your question of how we humanize Mike, he was portrayed by the government as almost a caricature of like an iron fist CEO, and we knew going in and promised an opening that Mike would testify, and it was really important that he testified because he had a very compelling personal story. He was not, someone who had his wealth handed to him and didn't earn it. He was very much a self-made guy, came from very humble beginnings, got scholarships at all of his institutions, and invented this technology and founded the company, ultimately rose to very, the very height of success, but did it through hard work and his own intelligence. And we needed to tell that story to humanize Mike. And that's why one of the main reasons why we called him. And I thought his testimony was just dynamite, and was a really important part of the trial. But one thing I wanted to flag, which I've never done in another case and was quite interesting, was we actually had two shadow jurors sit through the trial, and sort of acted as if they were jurors, were only in the courtroom when the jury was hearing evidence, and they stepped out when it was just proceedings before the judge. And that gave us some interesting real-time feedback.
So, for the audience members who are listening who don't know what that is, can you explain what a shadow juror is? You briefly did, but how you pick it, what they think they're there for, that sort of thing.
Yeah, they were just two ordinary citizens, much like the jury pool we selected from. And we had two of them, and they were instructed to appear in court every day when the trial began. And if there were proceedings in front of the judge outside of the presence of the jury, to step out of the room so they weren't tainted by any information that the jury wasn't hearing. And what we did was, at the end of every trial day, the two shadow jurors would be called by a member of our team, and we'd get a report on their impressions of the day, what they thought of this witness, that witness, what themes they saw emerging, generally how it was going. And I was quite skeptical at first that I didn't think that this would be particularly worthwhile or useful. And you can't read too much into this, because after all, there are only two people, and we had a jury of 12 and six alternates. But there were times where I thought, boy, we had a really great day in court and everything was crystal clear. Jury has to be completely on top of this. And the feedback we got was not so clear. And that was instructive, that we needed to go back and make sure we did a better job of just simplifying as much as we possibly could, because these were incredibly complex topics and concepts for a jury to understand.
You mentioned that you use the jury consultant for the traditional, traditionally how we lawyers do in order to pick the jury. And, what should the makeup be? How should we strategize in choosing the jury? What insights did the jury consultant have for picking a jury for this particular case?
Well, I think we came to around to the view with their input, but also heavily influenced by our own views, that we had I think we had the more intellectually honest case, but it was also relatively complex. And we wanted jurors who were educated, who, we weren't afraid of people who had maybe had some background in the software industry, or who were engineers, even folks who may have had a little bit of accounting experience, because we felt like our defense required some sophistication.
Right.
And
They would at least understand the issues.
yeah, I mean, the government, tried to really boil things down in a very simplistic way. And, I found at times an intellectually dishonest way, but arguably an easier to understand way if you accepted the way they framed the issues. So our strategy going in was to pick a smart jury, and one that we thought would pay attention. And it was successful. We had a fantastic jury. They were remarkably attentive. They were there every day, never late. It was quite amazing. They were more than I could have ever expected and hoped for.
And you were in San Francisco, which is actually a great place to pick a jury that's not just educated, but also educated in exactly the industry and the field that you needed them to be. So that was a good. I know that your client didn't want to be in the United States at all, but at least of all places, he was in that area.
I think it was a good place to be. In the end, it was the first trial I've had in San Francisco, but it was a great experience, and the pool was a good pool to draw from. And like I said, we were very happy with the members of the jury that we ultimately got.
I'm curious if your shadow jurors had any feedback or any thoughts on Mike and his relatability, but also like their impressions they got from his worth. And I ask that because sometimes prosecutors, especially in white collar economic crimes cases, they focus so much on how much someone's made or how many lawyers they have on that side and how they try to paint that in a very negative light. So I'm just curious if your shadow jurors had any feedback on that.
Look, going into it, we had the debate you often have on this issue, like how many lawyers should we have at the table? We don't want to give the impression that, Mike is over lawyered, but, we kind of figured out pretty quickly there was no hiding the fact that he had a large legal team supporting him. It wasn't just the lawyers who were in court every day and at the podium. We had a large team, working behind the scenes, many of whom came to court at times every day. And there really was no way around the fact that he had a lot of people supporting him on the legal side. How we ultimately, I think, overcame that issue was through a stroke of good luck and a big mistake that the prosecutor made. And hear me out on this because it was actually quite remarkable how it played out. This is toward the end of the case. We were into the defense case, and the government had called as a summary witness an FBI agent, the case agent, to put in the normal stuff that a summary witness does, some documents and charts and the like. And so we did the same thing, and we called a senior associate from Clifford Chance's London office. But to just put in factual information, obviously, as you know, summary witness can't testify to the underlying facts or
Right.
offer opinions like an expert. So it was fairly neutral testimony. And for whatever reason, the prosecutor decided to really go after her credibility, which was quite surprising. And he did it in two ways that the judge ultimately found objectionable. One was he, in the sort of guise of reviewing her experience, which it's hard to see how that was even relevant to the testimony, but he highlighted the fact that on her law firm bio, she noted that she had experience in extradition law and even lingered on, well, what is extradition? And he didn't tie it directly to a representation of Mike Lynch, but it could not have been more obvious that that's where he was going. And, we found that highly problematic. But then he also asked her questions about how she prepared for her testimony. And he did so by saying, well, did you prepare with Mr. Heberlig? And she said no. And he went through the list of lawyers who were representing Mike Lynch one by one, and it was
Ah,
it was upwards of 20 lawyers. Okay.
ah, yep.
And he knew exactly who had prepared her for her testimony. And it was two lawyers who weren't among the list of the 18 or 20 that he highlighted.
He just
So
wanted to read the long list.
he wanted to read the long list, and it really wasn't relevant to her testimony. So what happened is, we after I think during the testimony and also after, we objected. We may have even moved for a mistrial about the extradition issue. Judge didn't grant it, but he came back the next morning and called out, the prosecutor for making objectionable lines of inquiry. And so he brought the jury out and he instructed them. And to get back to what, led to this story, on the issue of resources and the number of lawyers that Mike Lynch had representing him, Judge Breyer said to the jury, now, ladies and gentlemen, there were some questions yesterday about the number of lawyers who represented Mike Lynch. I want you to know that a person who has resources, there's absolutely nothing wrong with hiring a large number of lawyers to defend oneself. In fact, he's essentially obligated to do so, to have the fullest defense he could possibly have. But
Wow.
this was the really interesting part. He then said, and by the way, if you think Mike Lynch is out resourcing the United States of America, think again. They have essentially unlimited resources to prosecute this case. They have the FBI working for them. So don't for a second think, poor United States, you're being out resourced by Mike Lynch. And it was
That's
remarkable.
amazing. Oh
I
my.
mean, we couldn't have asked for a better instruction, and it had exactly the effect that you sort of brought up that led into this. Making the jury think, yeah, okay, he has a lot of money, but a person who has resources should defend himself. They're going up
Yes.
against the government that has
Yes.
an obviously enormous amount of resources itself.
Absolutely. Absolutely. Wow. I'm really glad you shared that story because so much of going in and prepping for a trial, similar to this, right? Economic crimes, white collar, whatever people want to call it, is, how do you deal with that? That wealth, I call it like almost like a wealth tax in the courtroom.
Mhm.
It's like a burden that no one speaks about, but it came out in such a unique way in your case because it's the government invited it and they got shut down. Wow, that's incredible.
Yeah, I mean the other way it came up was yeah, obviously he made a lot of money on the acquisition because he was a founder and owned a significant percentage of Autonomy. But I mean, the truth was is he owned those shares before Hewlett-Packard came along. They were worth hundreds of millions of dollars, and he could have sold them at any
Right.
time and made that money. So he didn't need the Hewlett-Packard acquisition to become a wealthy man. He was already a wealthy man, and that was important too. It helped with the, lack of motive, and it was not a case where, he only would have made that money if the acquisition occurred. He didn't really need the acquisition, and even held out, in terms of negotiating the price and in ways that showed he wasn't desperate for this to happen. And that was helpful too.
So the government's case, I know that you had an, unique insight into how they would kind of try the case. They had tried the CFO. Did they follow that sort of, pattern? Did they do the same strategy or did they shift in trying this case?
They shifted it somewhat because, the core accounting decisions, it was really hard to pin those on Mike Lynch. He wasn't directly involved in them. So they made the case more about disclosure, but they also really went all in on there was a whistleblower in Autonomy's history, about a year before the acquisition, who raised some allegations in real time, and within about a month of doing so was fired by Autonomy, and then later entered into a substantial six-figure settlement with the company to resolve his claims. And I think the government felt like that was their way to show Mike, tried to cover up the accounting, and that, firing this whistleblower was a way to try to shut him down. So from our perspective, they went all in on this guy, and called a number of his subordinates and him. And I think at the end of the day, it really backfired on them because it was largely a sideshow. I mean, the quote unquote blower activity was only covered a part of the time at issue. It was relatively early in the alleged conspiracy, but the guy himself proved to be, a largely incompetent employee, uninformed on the issues that he questioned, and engaged in wrongdoing both in real time at Autonomy, and then, from our perspective, lied on the stand. And I think we were able to
Right.
prove both things. And so the government putting all their eggs in that basket, I think, was a mistake, because the jury, I mean, they told us afterward they didn't accept his testimony,
Right.
uh,
It
and that was
backfired.
it backfired, I think.
Yeah. Well, I'm curious, was the conviction of the former CFO, Mr. Hussein, admissible? Was that known to the jury?
It was not known to the jury, and the way we dealt with the prior testimony from both the criminal case and the UK case was just to generically talk about prior proceedings. Um, I suspect the jury speculated that one of those prior proceedings might have involved the CFO. But to their great credit, one of the things we learned when we were able to speak with them after the verdicts was that none of them had Googled the case. And one of the first things they asked us were, what's the deal with Mr. Hussein? What happened to
Wow.
him? Where was he? And we were able to share, and they were all sort of blown away. And it was genuine. It was obvious that they had honored the court's instructions
They
and not.
actually followed the rule of law, Brian. Oh my.
It was phenomenal. I mean, God bless them for doing it.
Yeah. So you were able to keep the civil suit out and the conviction of Mr. Hussein out. I mean, I assume because neither of those bore direct liability on or any admissions by your client.
That's right. And for the CFO's trial, we obviously weren't a party to that. For the civil case, I mean, that was a little trickier because the UK judge had made some explicit factual findings that were, adverse to our position in the criminal trial, including some on Mike's testimony. And we were fearful that the government might try to bring that in. We thought we had a pretty strong Rule 403 type argument that it would be prejudicial. And to their credit, the government didn't try to bring in that evidence. I think they realized that that was not consistent with the with the rules in a U.S. federal criminal proceeding. So we were in agreement with them that just to refer to it generically as a prior proceeding.
Okay. The judge at one point, I believe I read an article that he made a comment about the length of the trial and that it was taking so long that I think he said that, you all are going to lose the jury. Was there ever concern that, okay, it's 11 weeks, at the end of it, it was 11 weeks, but along the way, is there ever a concern that this is taking very long? Perhaps we don't put on a defense case because if we do that, you know, we run the risk of keeping this jury here for so long. They want to split the baby and just find some guilt on some counts because they want to go home.
Yeah, that was a real issue. And, look, if you ask the prosecutors, they would probably blame us. I certainly blame them. I mean, their original predictions for the length of the trial were that it would be a 3 to 4 week trial. And then, as we got to like the pretrial conference, it was, well, it'll probably be more like a 6 week trial. And it stretched, and their case in chief
Nearly
ultimately,
double.
yeah, their case in chief was 9 weeks. And, they said, well, we didn't anticipate the long defense cross examinations. I didn't really think that that was fair. I mean, yes, some of our cross examinations were long. From my perspective, that was because they only hit the issues superficially, and we needed to unpack a lot of stuff. But it did cause us to be very selective in our defense case. We were able to bring out a lot during our cross examinations that we didn't need to call defense witnesses to prove because we felt like we had proved some facts during crosses. So we ultimately only called, I think, 3 witnesses and our client. And our total defense case was about a week and a half. And then we shut it down and went into closing. So it was 11 weeks total. But we knew we were running up against a deadline where at least a couple of the jurors had mid-June travel plans, and they had been told at the outset of the trial that it could go as long as sort of the end of May. Well, we got to the end of May and we weren't done yet, and so we were quite nervous that we might lose some jurors. And even though we started with 6 alternates, we were down to one by the end of the trial. So yeah, it
Wow.
was a real issue. Fortunately, we got it done in time, and then they only took about 2 days total to deliberate.
So it sounds like the government's case was really just based on inferences, right? Nothing that could really pinpoint any wrongdoing whatsoever by your client, Dr. Lynch. Yet you promised an opening that he would testify. And once you promise something an opening, you have to give it. Otherwise, it's going to be thrown in your face. And then you're running against the clock, and you end up calling him, and he testifies for 4 days. Tell us a little bit about that. What was the strategy and, having him testifying in such depth, and how did you prep him for that? Can you walk us through that strategy a little bit?
Yes. So the plan all along, as you gleaned from the opening promise, was to call Mike. And there were a couple of reasons for that. I mean, first and foremost, he just is a phenomenal witness, smart, knew all the issues, and very personable and charming in a way that was very different than the caricature that had been presented at trial. So we knew we wanted to call him. We also had the fact that in the UK civil trial, Mike had testified. And the way it works over there is, you don't do direct examinations. Your direct is effectively a written witness statement. So he had a 400 plus page written witness
Oh
statement,
my.
and he was cross-examined for 20 days on the stand. Yeah. So we knew
Oh.
we knew
Oh.
that if we didn't
Wow.
call him, there was, the government had the ability to just admit portions of his trial testimony from the UK proceedings,
Absolutely.
and it would be taken out of context, and there wouldn't be the full ability to contextualize things. So we had a pretty good idea going in that we were going to call him. And so the way we prepared was we, at each of our law firms, respective law firms, we have large white collar teams, and we tapped some of our partners who were not on the, trial team and hadn't been working on the case to take a few issues and spend a day, mock cross-examining Mike. And it was great. They were tough. put him through the paces. I mean, it was hard for them to master the trial record in the same way that, the prosecutors probably knew it, but they were former prosecutors themselves. They each had different styles they brought to the table. One was a jerk, one was the thoughtful guy, one was the one who tried to get under the skin. And it all, just showed Mike different styles of cross-examination. And he was extremely well prepared going in. Now, all of that occurred, I would say, in the month or two before the trial began. When we actually got into the trial, there was so much work going through the government witnesses that when we transitioned to preparing for the defense case, the focus was really on Mike's direct. We knew that he was ready for cross. And, Chris Morvillo put him on. The art was, how much to bring out on direct and how much to save for, cross-examination. And we had to make a lot of tactical calls along those lines. We didn't bring out a ton. We sort of had a high level take on his direct. And to my great surprise, there were huge topics that the prosecutors simply did not ask Mike any questions about. They focused on a couple of areas, but they left to the side huge portions of their case in chief. And I thought that that was an enormous gift to us because, we were able to position it in closing that, jury, how could you find anything but that Mike told the truth about those issues and that the government has effectively conceded them because they
Right.
didn't ask him any questions about them. It was remarkable. It left us in a great position for closing.
That's fantastic. For our audience listening who don't understand why his prior statements in the UK would have been admissible statements of a defendant like that are admissible in criminal trials. So I understand a little bit more understanding the UK case, why you made the decision to put him on, in addition to just who he is, who he seems to be. Had you put on a client before in a criminal case, Brian?
Yeah, so I've had this question before. I've actually had every scenario. So I've had call the client to testify and get convicted, call the client to testify and get acquitted, don't call the client to testify and get convicted, don't call the client and get acquitted. I would say in the prior trials I've had, I'm sort of thinking out loud. We've called the defendant at least in four of them that I can think of. So not
That's
averse
a
to,
lot, though. That's a
yeah,
lot,
yeah,
given that most criminal defense lawyers would tell you it's such a gift to the prosecutor when you call the defendant because they're waiting for it. And the burden, even though the burden doesn't shift legally, the burden in the minds of jurors just change, right? They're just asking, do I believe this person? So four's a lot to me to hear that.
yeah.
Wow.
Yeah, no, I know some defense attorneys take the view that I'll never call my client for the exact reason you just mentioned. The trial starts over when the client hits the stand. There's some truth to that, and obviously, if your client is disbelieved, you're likely going to lose the trial. Um, but but I think that juries often, want to hear from the defendant, particularly if the case involves allegations of false statements or disclosure,
Right.
issues
Tell
where,
us why you didn't do it. Yeah,
yeah, yeah, like, did you tell the truth? I mean, it can be such an advantage if you have a credible, persuasive client. And, in my experience, I mean, prosecutors obviously have a lot of trial experience, but they don't often have a ton of cross-examination experience when they're
that's true.
in
That's true.
government, and it's a very different skill. And if you can, put the client on and survive cross-examination, it leaves you in a position as a, lawyer for a criminal defendant to say, like, they had a free shot at him. They could take their best shot, to attack his credibility, and they failed. And, not only, I mean, I think we argued in this case it was a close call and we thought we had sort of won the trial even without putting him on. But then you add on top of it, they didn't meaningfully touch him in cross-examination. It just leaves you in a great place. So I'm a firm believer if you've got a client who can withstand cross-examination and there aren't, sort of other evidentiary issues that'll come into play if you call the client, that you should think about doing it. It's worked in a number of cases for us.
So much of what we do is, just that, making the judgment calls that, come down to really just, is someone going to be likable? Is someone believable? Putting that together with facts that you have and the evidence in front of you. And a lot of what we do is storytelling and acting, if you will. I mean, in a real authentic way, but at the core of what we're presenting to a jury, we have to think about these things. How are they perceived? And some defendants, as you just said, just don't have the personality to put on the stand. I know that your client, I think, has a very heavy British accent. And what's interesting is actually, I was reading about a couple of weeks ago, Cornell had a study done in 2018. It's called Accents We Trust. And they found that people perceive information with more credibility coming with a British accent than an American English accent. And I thought that was interesting. And when I read about this case and the verdict, I wondered, wow, like I wonder if that lended somewhat to believing Dr. Lynch. But it sounds like it was so much more than that that made him credible on the stand.
Well, that's an interesting study. I mean, we had a number of British witnesses testify, and there is something to be said for that, dignified British accent. It sounds intelligent. I don't know how to put
Yeah,
my
I know
finger
what you
on.
mean. I know exactly what you mean. And it's true. It's something that you don't know how else to say it because I don't either. I agree with you. It's just you sound like you want to believe the person, right? I get it.
But what I would say Mike did a great job of during his testimony is he turned and faced the jury and talked directly to them, made eye contact, really personalized things. And I wasn't sure that that would work, but they didn't shy away from, making that direct eye contact back with him. And
Did you tell him to do that or did he do it on his own?
he wanted to do it, and we talked about whether it made sense to do it. And ultimately, yeah, we advised him go for it. And it really worked. I was a little skeptical whether it would, but I think it was effective. Yeah, it was very conversational. And I thought it was interesting the way he did that.
I read that at some point he said to the jury, if you take a microscope to a spotless kitchen, you'll find bacteria there. And making the analogy that that's the same with any company, right? That a company can be perfect, but you'll always find something if you're looking for it and doing as deep of a dive as DOJ has done here, right? Were
Yeah.
those lines his own, or were those kind of worked into his verbiage through prep?
Well, he was a master at analogies, and we talked about a lot of them during prep. Some of them worked, some of them didn't, but I thought he was exceptional at taking complicated, concepts and turning them into these fairly straightforward analogies. And the one you mentioned was a great one that I actually co-opted and used in closing. He used this: go into any kitchen, look under a microscope, you're going to find bacteria. I sort of took that and said the government has tried to find, hundreds of millions of dollars of revenue adjustments that were, wrong at Autonomy. They portrayed the kitchen as, filled with grease and grime and trash on the counters and, something that would have been obvious to the owner of the house when you walked into the kitchen. That's a dirty kitchen, right? That's what they wanted to show because Mike wasn't
Exactly.
an accountant. Well, I sort of turned it around and said, when you take away all of the errors that the government's accounting expert made and really boil it down to the true issues, it was something like less than 1.5% of Autonomy's revenue over the 2.5 year period. That's much more like the bacteria under a microscope, or I think I said like a loaf of moldy bread in the bread drawer. Like you don't obviously see that. Um, and that was all due to Mike's great, analogy that he used in his testimony.
Let's talk a little bit about your closing. Um, I read the closings, and yours was, I thought, fantastic, Brian, first of all. When you started off, you said, three times during, I guess, the government's closing, you thought you were in a different trial because, and you went straight to your client, right? You said he was on the stand for 4 days. What they talked about in their closing and how they painted him, that's not what we saw at all. And then
Mhm.
for, 8 pages of the transcript, your closing focused on the beginning 100% on your client. And I wonder, like, clearly you were well aware and knew that, okay, the jury, in their minds, the burden may have shifted and they're going to just ask the question, do they believe my client? So let me just focus on it. Let me talk about the elephant in the room. But why was it so important? Um, to start your closing that way and structure that way, to connect with the jury?
Yeah, well, so there were two parts to it. The part that was unscripted was, and I've used it, once before in a prior trial, but it was this imagery of, I thought I was in the wrong courtroom. I recognize you, the jury. I recognize the judge, Judge Breyer with his bow tie. Of course, you couldn't miss him, but I didn't recognize the description of the evidence that the prosecutor gave you this morning. And I knew I was going to use that sort of storyline, but I didn't know what I was going to focus on until I heard the prosecutor's initial closing. And
Right.
my plan was to pick the top two, three, four issues where I thought they just got it wrong, and our view was fundamentally opposed to the way they put it. And so, I had a lunch break before I had to go. I think he went in the morning. We had a 45-minute lunch break, and I went in the afternoon. And I just picked what I thought were the top three issues and went right at them at the very beginning of my closing. The part that was scripted was to focus on Mike in the beginning. And as I said, we had the gift. He testified, and I thought he did a great job. So I wanted to focus right on him because you don't always have that, obviously. And what I found most compelling was, given this, 9-week presentation of evidence. Sorry, my dog. Given this 9-week presentation of evidence covering, dozens of issues, they largely didn't ask Mike about them. And, I found that stunning, and I thought it would, resonate with the jury that they should believe Mike. They have no choice to believe Mike
Right.
because he wasn't impeached at all on those topics. And it was also gratifying afterward to find out that that argument resonated.
Don't worry about your dog. As you know, Brian, I have dogs too, so it's totally fine. Um, you mentioned several times since we've been talking about juror feedback. I have to say, for especially the audience who they're not used to trying criminal cases, and they're not used to witnessing criminal cases. Um, you don't always get to talk to the jury. In the Southern District of Florida, it's very rare. That never happens. Clearly here you did get to talk to the jury. Ultimately, what did they express to you nailed the win in the Lynch case?
Yeah, look, my experience is similar to yours. This is the first time I've ever talked to the jury after a verdict, and I didn't know what to expect. I also was surprised that the judge gave the jury the option of coming back out and talking to us if they wanted to, or they could just go home. And all 12 of them came out and sat with us for over an hour. And we had,
After an 11-week trial, wow, that's amazing.
yeah,
Kudos to them.
kudos to them. We had a back and forth. They had questions of us. We had questions for them. It was really, really interesting. I'd say, what carried the day for us. What surprised me, and this was also a little bit scary, is they said they sort of quickly dealt with most of the issues and found that Mike and Steve were not responsible for them. Sort of like 75, 85% of the case, they early on said there wasn't enough evidence on, these categories of transactions. And what they zeroed in on were two of the disclosures that Mike made on these quarterly earnings calls, and they were areas where we knew we probably had our greatest vulnerability. We had, fronted them in his direct examination, and he gave an explanation. But most of the defense, if you will, he was planning to do on cross-examination, and the prosecutors never asked him about either statement.
Why
So
is that? Do you have any sense why that is? Were they just trying to rush the case and finish?
I think they didn't want, I think Mike had answers and they were afraid of them. And they thought that it would give him an opportunity to explain away the charges. But that's a double-edged sword, right? Because if you don't take your best shot and, challenge the defendant on, these key issues, it's very hard to say later, although they tried, that he lied, right?
Right.
Because if you don't
Right.
try to impeach him, then I don't think it's as persuasive to say that he was a liar. But that was their strategy. That's what they did. And the jury focused on those issues. And it was like, oh my goodness. But in the end, they concluded there just wasn't enough evidence that what the government said was true. And I think a large part of it was due to the fact that the prosecutor didn't challenge Mike on his statements. And so, if they had some doubts, I would think that, you got to go in favor of the defendant when the prosecutor hasn't tried to impeach the testimony at all. So that was one big revelation from the jury. They also, as I said earlier, they didn't credit the whistleblower. That was huge for us because it was such a big part of the government's case. Um, and look, overall, they just were they were quite conscientious and they said they went through the jury instructions very carefully. They got a written copy of them back in the jury room, which, they're not the easiest to digest. They're filled
That's an
legally.
understatement of the century, Brian.
Yeah.
Impossible to understand. That speaks volumes to not only how serious they took their charge, but really just the quality of the jury pool and jury that you had. Wow.
I know it was something. The one thing they said that was scary, although fortunately we survived it. The only alleged victim in the case was Hewlett-Packard, and our defense was HP wasn't a victim. They sort of raced through due diligence. They didn't care about any of the issues that are now part of the trial in real time. They just wanted to buy the technology, and that's how we pursued it. And the jury said, yeah, we quickly ruled out HP as a victim. We didn't think they were a victim, but yet we still considered the evidence because we thought, well, somebody else could have come along to buy the company. And oh my God, had they convicted on that theory, which was not a viable theory, it would have been tragic, but fortunately they
Right.
didn't.
So this is not your first big trial win. You secured an acquittal for David Rainey. He was the highest ranking BP executive charge in connection with the Deepwater Horizon oil spill. It was a false statement charge in New Orleans. You also secured a mid-trial Rule 29 acquittal for a businessman that was charged with bribing a former Pennsylvania Treasury with campaign contributions. You've had your fair share of wins, which is remarkable, like I said earlier in federal court. What's your secret here?
I wish I could tell you, and I'd win them all. But look, I think a few things go into it. One is you've got to put in the work and be just extraordinarily prepared. And when I'm in trial, it's all consuming. I do nothing else. I don't have any free time. I don't see my family. I work 14 to 16-hour days. And, my trial mantra is you cannot outwork me. And, the day that I can be outworked, I'm probably not fit to be a trial lawyer anymore. So that's hugely important to be prepared and know the case as well as you can possibly know it. Then, a lot of it is judgment, how much to go into certain issues, when to press a witness on their credibility, when to take the good stuff from the witness before challenging their credibility. I mean, these are all things that are, there's no black and white playbook. Some witnesses you just decide that, you know what, even though he or she has some good things to say, I've just got to take down their credibility because the bad things they have to say are overcome any of the good things. And then there are other witnesses where you can get away with eliciting all of the favorable evidence before doing some impeachment. So look, a lot of it's judgment and experience. And I've been fortunate, had some great mentors at Steptoe, got good trial experience as a younger lawyer, and have gotten a lot of trial work at a private firm, which is not the norm in many cases. So I've been very fortunate in the trial work that I've had.
I'm going to pick up where you just left off that, about your career at Steptoe really lending to you being able to be a dynamic trial lawyer. You graduated Georgetown in 1996 and you haven't left Steptoe since you entered their doors that year. It's rare these days for a lawyer to stay at one firm for 28 years. I mean, lawyers, feel like they're hop, skip, and jumping every 3 to 4 years nowadays. What has drawn you to stay at Steptoe?
Look, it's been the mentors I've had and the practice. I've was fortunate early in my career to get involved with the white collar group at Steptoe, and the two mentors I've had, Reed Weingarten, my closest partner at the firm. We've worked together for, almost that entire time. It's been just an absolutely wonderful mentor who's taught me, everything I know as a trial lawyer. And I had another one early on, another former prosecutor named Mark Hulkauer, who also a phenomenal trial lawyer in his own right, who tragically got colon cancer as a young man and died in his late 50s. Um, and between the two of them, the work we were doing at Steptoe was high profile, cutting edge. They were going to trial. I hit the stage of my career. Many young lawyers, come to a point where they decide, can I stay at the firm and get, if you want to be a trial lawyer, can I stay at the firm and get the trial experience I want and need to progress as a lawyer, or should I do something else? Should I, become a federal defender or a federal prosecutor? And I went through the same thought processes, as people do, but I was fortunate that, at that stage of my career, which was probably seventh, eighth year associate, we had two really interesting high profile trials that I was like the lead associate on. One was the former general counsel of Tyco, Mark Belnick, who went to trial in New York State Court, which was quite interesting. And then the former CEO of WorldCom, Bernie Ebbers. And he also went to trial in the Southern District of New York. And I decided I wanted to see those two cases through. And by the time they were done, in I guess the early part of 2005, I had gotten two great trials under my belt. I had my second child during the second trial, and I'd made partner at Steptoe. And I sort of, took a breath and said, maybe I don't need to leave after all.
Right.
I'm
It
doing
just didn't seem to make sense, it sounds like.
Yeah, I'm doing what I love to do. I'm getting great experience here. I'm working with people that I really enjoy working with. This law firm thing might work out. And look, on top of that, I've really enjoyed the people at Steptoe who I don't work with on a day-to-day basis, but we've got a great firm culture, as you said at the outset. A lot of women in leadership, just colleagues I've worked with for a long time in firm management roles who I really just enjoy being around. And that's not enough, on its own necessarily to keep you at a firm for as long as I've been at Steptoe, but it's a real bonus that I love the practice. I love the core group of people I work with. And on top of that, Steptoe's this wonderful democratic partnership filled with, interesting dynamic people.
You mentioned obviously that you've never been a prosecutor or a public defender. What drew you then to the criminal side? Because it's rare, well, not rare, but a lot of prominent criminal defense lawyers seem to have had come from either background. And you grew up in the ranks of a firm. But what drew you to this line of work to begin with?
Well, I knew, coming into the firm that I had an interest in litigation and I thought I wanted to do trial work. My father, I'm the oldest of three. My dad's a lawyer. He was sort of a generalist trial lawyer at a regional firm in Syracuse, New York. And, I sort of grew up hearing his trial war stories and thought that sounded interesting. But I was not one of these people who was knew from an early age that I wanted to be a criminal defense attorney. I just knew that litigation sounded like it would be interesting. And so when I got to the firm, I sought it out, and I pretty quickly realized that most of the trial work at Steptoe was happening out of the white collar group. And unlike a lot of firms that say they have white collar practices but are mostly doing corporate investigations, we had a real trial practice. And so, as an early lawyer, maybe first year into the firm, I really enjoyed the criminal work I was doing and just decided to take on as much of it as I possibly could and try to make myself indispensable to Reed and to Mark and the other partners in the group. And it kind of took off from there. And I have found the work to be quite challenging and interesting. What I love about being a criminal defense attorney doing mostly federal cases is you're an expert only in the process of how to do trials and in criminal procedure, but like you learn something new all the time. I mean, you mentioned the BP trial. There was a time I became an expert in like deep water drilling. I now
Right.
can't remember any of that stuff. Lately, I've become an expert in software revenue recognition. I hope to never have to remember that stuff again. So it's just it's fun.
In your 28 years at the firm, and being a lawyer in general, how has the legal profession changed in your eyes? And, more specifically, how has it changed for women and gender equity?
Well, that's a great question. I would say I'll start with how the practice has changed and then get to the gender equity question. So one thing that's changed for for me in the types of cases that we've handled is everything has just gotten sort of bigger and more expensive and more complicated. And part of that is driven by, I think, changes to discovery. Like, in the old days, you'd have a case where the discovery would consist of like 5 boxes of paper documents.
Right.
There weren't emails and text messages and, you know, terabytes of information. You could do a trial with one partner, one associate, maybe two partners, two associates. That was like a big team back in the day. Now, this trial we just came off of, I think we had upwards of like 30 lawyers or maybe more between the two firms. We had essentially a mini law firm working on the case. It's just different.
Right. Well,
But
electronic evidence has changed that. I mean, now, a defendant's phone or going through their emails, the government just has much more that they can prosecute and produce. So, yeah, no, I could see that for sure.
totally true. And in terms of women in the practice, I mean, I think things have changed for the better in that regard too. When I started out, there weren't many women criminal defense attorneys, to be honest with you. Um, there was at least a perception at the time that it was sort of a man's game, a young man's game. And if you wanted a family, this wasn't the right line of work for you. And in law firms, that also tended to be the case. There was sort of a track where, you know, FaceTime was expected. You needed to be in the office. You needed to be working these crazy hours that made it very hard to, also maintain work-life balance and have a family. And for young mothers, that it was a hard place to be. I think that's changed. It's not perfect still. Obviously, it's still very hard to strike the right balance, but there's a lot more flexibility these days, in my experience, to have alternative work schedules, to, you know, what's most important to me and to the practice is being able to do good work. I always think of our practice as kind of a meritocracy, but how you do it, when you do it, if you need to take a break in your career path, like that's totally fine and acceptable these days. And I've lost a few really talented young women associates who've went on to become prosecutors, who've been among the best lawyers who've ever worked for me, and I've obviously been delighted to see them go on to have successful careers at the Department of Justice. But would have loved to keep them and help them become partners at the firm. So it's changed a lot. I don't know that I have all the answers. In fact, I know I don't. But I think it's a better and more welcoming place than it probably was when I started 28 years ago.
And certainly that's due in part to intentionality. I mean, equity doesn't come from, turning a blind eye, or you have to be intentional about it. At least I find that. That's my experience. Firms have made that a priority, certain firms. And Steptoe, certainly, I mean, in the beginning, I mentioned equity partnership at Steptoe, 28% are women. That had to have been intentional somehow. You are in firm management. Why is that a priority for the firm?
Say again, I'm not for man. I just didn't
You
hear your
are in,
question.
no, you are in firm management. And, why is that a priority for Steptoe?
Oh, I see. Yeah. Well, it's a priority for Steptoe. One, it's just the right thing to do. Two, clients expect it. They expect diversity at all levels. It leads to better legal representation, frankly. And at our firm, there's a real tone at the top. Our chair is Gwen Renegar. She's a contemporary of mine. We were summer associates together. She's phenomenal, and she's leading by example. I mean, she's a really strong leader. I think since she's been chair of our firm, we've had more women partners chair other important committees of the firm, like the Professional Advancement Committee or the Compensation Committee. So it's partly intentional and it's partly having really great examples of leadership for others in the firm to, follow and try to emulate.
I want to talk about something you mentioned when you were talking about how you approach a trial. You said it's all consuming for you. There's no free time, 14, 16-hour days. You outwork everybody. An 11-week federal trial in a different city than the one you live in, will take a toll on you. How do you manage to stay mentally and physically sane and healthy during that period of time?
Well, it is a challenge. In this case, I moved out to San Francisco on March 1st and, didn't get home until about 2.5 weeks ago, early June. I think I had one weekend where we didn't sit on some day during the trial. We had an extra day off, so I managed to escape for like 36 hours.
And I should note that you're married with kids and the whole gamut. So, uh,
Yeah, I mean, so number one, first and foremost, my wife is unbelievable. We were law school classmates. She's a lawyer herself, although not currently practicing. She keeps me on my toes, and it was a great relief to me that I knew that things at home were taken care of, and look, it was hard on her. Two of our three kids are in college, so there's only one left at home, but he has a busy high school schedule, and not having someone to share the load with as we usually do was a big challenge. But she's always supported me in my career. I'm so thankful to have her and to be able to talk about legal issues with her. She, as a lawyer herself, knows and is interested in those issues. But during the trial, look, I don't have a good secret for how to stay with it. And I'm not sure that I succeed. I'm not good at moderation. I'm not good at balance during a trial. You just have to sort of work your way through and take care of all those issues when it's done. And that's what I'm focused on now, trying to get healthy again and reconnect with my family.
now that the trial's over and you're trying to take those steps to be back at home with the family, what do you plan on doing this summer?
I've got a few personal trips that I'm going to take, mostly vacation type trips, and there's a little bit of work out there too, and hopefully more will come in as a result of this. But after an 11-week trial, I'll be honest with you, I'm a little burned out, and I really am looking forward to the summer months to try to recharge and come back, ready to go on the next great adventure that I'm sure will be right around the corner.
I read on your LinkedIn profile that you said when you're not working, you're reading fiction, amongst other things like playing golf and listening to music. So, what's your latest fictional read?
So I had lately, and this is when I say lately, pandemic lately. I used to read a ton of just hardcover books and paperback books. And during the pandemic, I became much more of an audiobook listener because we got a dog, and I started taking really long dog walks and listening to books. And so the most recent book, I'll give you two. I listened to a book that I began before the trial, and then I had a hiatus, but I just finished it when I came back. It was called The Fraud by Zadie Smith, a really good book about London in the sort of 1800s, and sort of parallels to Donald Trump. I know that sounds weird, but it's sort of an imposter to an heir to like a royal claim, and I'm not doing it justice, but it was a good read. And what I just started rereading, and I never got to the end of it, but I swear in my upcoming 3-week trip I'm going to get through it, is Infinite Jest by David Foster Wallace, which he's one of my favorite authors, and it's a long one, so an 800-page book with
Oh,
multiple
wow.
footnotes. I got to get through it, but a great
Well, you
fiction.
have 3 weeks. You have three
I
weeks.
know,
That's what you're going to be doing.
lots of airplane time. I can do it.
Exactly. So, Brian, we're coming to the end of our show. And towards the end of the show, what I'd like to do is I like for people, who are listening, either experienced lawyers well into their career or someone who's just in law school, to pick up some tidbits and words of wisdom from our guest. So, I'm going to ask you, what's your greatest strength and biggest weakness?
I mean, it's hard to say greatest strength. I don't know. I don't normally love to talk about myself. I mean, I think I'm tenacious, I'm efficient, and I'm somehow managed to have success in trial. So, I mean, those are some strengths of mine. Weakness, I, I guess I'd say a couple of things. I have difficulty with moderation, as I've told you. I'm sort of all in on trials, and that's not always healthy. But one thing that has happened to me in the past, and I tried to overcome it this trial. I'm not sure I was completely successful. Is sometimes I just get so into it that I can be a bit of a jerk in a trial to opposing counsel or sometimes even witnesses, and I really have tried hard to check that impulse. because as you know, our profession can be combative at times, but um, professionalism is critically important, and I think I've gotten better. Although I've not completely overcome that tendency to have the game face on all the time and just be hard charging, and not so worried about those personal relationships.
Well, at least you're self-reflective enough to know that and understand it about yourself and try to change it. I mean, I think 80% of our population doesn't do that to begin with, so you're already winning, in my eyes. If you weren't a lawyer, what do you think you'd be doing?
I don't know. I mean, this was always the career path I had for myself. I mentioned my father. I just assumed I was going to be a lawyer, and this is, the way it's worked out. I mean, there are a lot of things I'd love to be doing. I'd love to be a
Such
writer.
as?
Oh, I'd love to be a writer. I, would love to travel more. Lots of, things in our personal life are just hard to keep up on when you're a busy trial
Yeah.
lawyer. None of those, hard to imagine them being professions.
Yeah,
Um, but there's a lot of things with more time I'd love to do. I'm not sure if I'll ever get that balance fully down, but I intend this summer to try.
good. And I hope you succeed with that. So, our last two questions. What's the best advice you've ever received?
That is a great question. Well, so I mentioned the mentors that I've had. Reed Weingarten has just been, an unbelievable mentor to me. And he, as I said earlier, he's taught me so many things about the practice of law. But the advice he gave me was really career advice. As I mentioned, there was that time where I was thinking, should I become a prosecutor? And he was a federal prosecutor, had an incredibly accomplished career, and as both a state prosecutor and in the public integrity section, prosecuted, many, many important cases. And I knew thought very fondly about his time as a prosecutor. So when I went to him for advice on, is that the move I should make at this stage of my career? What do you recommend? I was surprised when he said, I think you can make it here. You are talented at what you're doing on the defense side, and if commit to the firm, commit to this practice, I don't think you need to leave to be a prosecutor. And that gave me the confidence I needed because I wasn't sure if I'd be able to make it work by staying at the firm. And hearing that from him, the person I respected most and still do as a lawyer really helped me make the decision to stick it out. And I'm grateful to him for all the opportunities he's given me over my career. But that stands out because I was sort of at a crossroads and didn't know whether it made sense to stick around or move on to something else. And I would have missed out on all these amazing opportunities and experiences I've had, largely with him had I not followed his advice.
Wow, it sounds like you found quite a mentor in him. And I'm so happy that you have that because we all need that in our careers and our lives. Um, you, this is the last question I'll ask you.
Yeah.
You're talking to your 80-year-old self. What do you tell 80-year-old Brian about the legacy that you hope to leave and the life that you lived?
You ask all the tough questions, Vanessa. Um,
This is the fun part, Brian. Come on.
well, okay. So I hope what I tell myself is, and I hope I've not worked until I'm 80. I was blessed. Both my father and my grandfather, so my father's father, retired at relatively young ages. My grandfather was a World War II veteran, very humble background, and he retired, in his mid 50s and lived this very long life in retirement. We
Wow.
used to call it the life of Riley, just the sweetest man in the world. And my dad, not quite that early. He was a law firm partner, but I think he retired in his early 60s. Look, what I hope is that I continue to do what I love and have some success at doing it and help clients who need the help. But I think legacy ultimately to me is family. I want my kids to be more successful than I've been. I want them to have every opportunity in the world. And the other lesson I got early on from both Reed and Mark at Steptoe was family comes first, no matter where you are, what stage of life you're in. And I've tried to honor that. There are times, obviously, when, like this last trial, you can't necessarily put your family first, but in the long run, if you don't, what else is there? And I hope the legacy I leave behind is, successful kids who are doing things they love to do, and maybe a little bit of good work left for some clients.
Well said, my friend. Brian, thank you for being a guest on Athena Rising and for doing this. I truly appreciate it. And I should have said it earlier when you mentioned the two mentors that you had in addition to Reed. You mentioned your colleague that was a mentor to you that you unfortunately lost early. And I'm sorry about that loss. I didn't mention it earlier, but I want you to know that I know what that must have been like. And I'm sorry you experienced that. Thank you so much for your wisdom, your insight today, and as always, for being an ally to Athena's.
Well, thank you, Vanessa. I'm grateful for the invitation, and thanks for having me on.
Thank you for listening to Athena Rising Season 2. You've just heard from Brian Heberlig, a prominent trial lawyer and ally to Athenas who have risen and many who are on the rise. Brian told us about his trial victory in defending billionaire tech guru Michael Lynch, and a bit about what makes him tick as a person. If you like this episode or have other feedback for us, please let us know by either commenting on the platform you're listening to or by sending us a message via our LinkedIn profiles. They can be found at www.athena-rising.com or by following me, Vanessa Singh Johannes, or my colleague, Marisol Descalzo, on LinkedIn. We are grateful you have tuned into our podcast and hope you continue to do so. To all the Athenas and allies out there, let's continue to rise.